go ahead and get on to Google Meet. All right. So council that is on Google Meet, I've called the case of DO 11CV 2025-612. The counsel for Julia Peters has entered their appearance. Counsel for the Santa Fe County Board of Commissioners has entered their appearance. Gregory Williams has entered his appearance, and Gregory McKenzie has entered his appearance. Let me go ahead and have counsel that is on Google Meet enter their appearance. If you can go off mute for me.
Good morning, Your Honor. My name is Jean-Paul Jassy. I've got a Pro Hoc BJ application forthcoming. I am with Gregory Williams, representing CBS News, CBS Studios, and Associated Press.
All right.
Good morning, Your Honor. Apologize for not unmuting myself. I'm Scott Sauter, Deputy University Counsel for the University of New Mexico, doing business as the Office of the Medical Investigator.
All right, thank you. So let me ask, I know there's a number of preliminary matters I need to go through, but Mr. Summer, are you ready to proceed today?
Your Honor, we are ready to proceed today. However, counsel have been discussing this matter, and we are willing to continue the temporary restraining order until the underlying case can be determined, and whether or not these pending motions by CBS and the AP, whether they'll be granted admission into this case. So I don't know what the court's pleasure is with respect to that. In addition, Your Honor, we have a stipulated order from the OMI, or the Regents of the University of New Mexico, stating that they will limit unlimited production of the autopsy report. And I have a post-stipulated order in front of me, which has been signed by Mr. Sauter, or approved by Mr. Sauter, Mr. Boyd, Mr. McKenzie, and our firm. If I may approach the bench.
All right, let me get into that in just a moment.
Okay.
Okay, so let me address the preliminary matters that I had on my list here. So there's a motion to intervene that was filed by Christopher Hackman, Elizabeth Hackman, and Leslie Allen. I have approved that order. So those parties or individuals are now a party to this case.
That's correct.
All right, so with regard to the counterclaim and cross-claim complaint for Interpleader, I need to address that. So with regard to that matter and that issue, I'm going to invite the parties to brief whether the interpleader is appropriate in this case. I'm not going to hear from any interpleader defendants at this time unless I've granted a motion to intervene. All right, that leaves the two other motions that I'm aware of. There's a motion from CBS Studios Incorporated, Rule 25C, motion for substitution, or in the alternative, motion to intervene to join CBS Broadcasting Incorporated's opposition to amend petition for preliminary injunction regarding the estates of Gene Hackman and Betsy Arakawa-Hackman. There's also a duplicate motion from the Associated Press. I do want to address those two motions. So let me ask counsel, are you prepared to address those motions?
Yes, Your Honor.
All right.
Your Honor, if I may, we oppose those motions.
Okay. And
We
so,
we have not had an opportunity to brief them as they were filed this morning.
all right, and so, you know, these matters are set on an expedited basis at the request of your client. Under the rule, as I understand it, Rule 66, I have to set this matter for hearing if I issue a TRO within 10 days. If I'm wrong about that, let me know. So I'm under an obligation under the rules to set this matter rather quickly. which unfortunately, I think the downside to that is the normal briefing deadlines and schedule is hard to follow, given that I have to have a hearing within 10 days. So with that said, I do intend to entertain these two motions, and I'll allow you to argue them, Mr. Summer. I can't keep a temporary order granting injunctive relief in place for an extended period of time to allow for a particular briefing schedule to be implemented. If you think I'm wrong about that, I'll entertain your position.
Your Honor, with all due respect, I think that Your Honor can continue the temporary restraining order as it relates to the Board of County Commissioners, because the counsel for the Board of County Commissioners is going to retain the status quo while these matters are determined by the court and they're properly briefed, and the court can make a proper decision, having given us the opportunity to respond to the two motions to intervene. So I believe that the case law supports an extension of the temporary restraining order by agreement.
Okay. I'm going to allow the moving parties who are seeking to intervene to state their position today, and I'll entertain their argument, and I'll likely make a ruling on their request. All right, so I'm going to address those two motions first. And let me ask you, Mr. Williams, you're representing both the Associated Press and CBS News, is that correct?
Yes, Your Honor. It's actually two different CBS entities, one called CBS News and one called CBS Studios, but yes.
All right, and are you ready to proceed on your motions?
Yes, Your Honor.
All right. So I'll need you to address in your presentation Mr. Summers' request that I do not entertain your motion, and why I should entertain your requested relief here today. But I need to address these two motions. So why don't you go ahead and approach the podium, tell me what you want the court to do and why.
Thank you, Your Honor. So just so that I understand what the court has explained procedurally, we presented our motions, and just for the record, they were filed on Friday and served on all counts on Friday. I think they may not have shown up in the online court record until this morning, but they were submitted to the court and the parties on Friday. And we, as you know from the briefing, presented our standing issue, our ability to appear here in two ways. One, in our status as interpleader defendants, and second, alternatively, as proposed interveners. As I understand what the court has explained to this point, the court would like to receive further briefing on the issue of the interpleader process as being appropriate. And so what I would understand the court to be saying at this point is our status to appear as interpleader defendants is kind of on hold for now. It's not denied, but it's on hold pending the briefing. And so what I will present to the court is just simply some brief argument about our status to intervene. If I'm wrong, please correct me, but that is how I would like to proceed.
You may proceed.
Okay. So using our alternative bases for being heard here today and being a part of the case is under Rule 1-024, which is as a party interested in intervening. Just so the court understands the party's status, as you know, at issue in this case, and the subject of the proposed restraining order are public records that relate to police, camera, and video, and OMI records. My clients, the proposed interveners, are members of the media who have submitted requests under the Inspection of Public Records Act to either UNM through OMI or the County of Santa Fe through the County Sheriff's Department, or both. And so they have an interest in the records that the plaintiffs and the Hackmans here are seeking to block access to. So Rule 24 is a fairly low bar in terms of ability to intervene. As the court is aware, under Rule 24A, there's an intervention as of right proceeding. And that is if the proposed intervener has an interest relating to the property or the issue before the court. And that is clearly met here because these specific records that the parties are seeking are records that they in fact have sought and requested and are being blocked here. Even if the test, which I think is a pretty low bar for intervention as of right, is not met, there's also a permissive intervention under Rule 24B, which permits the court to allow a party to intervene if the intervener's interest has a question of law or fact in common with the main action or the pending action. And here that, again, is clearly met because these parties have the same legal interest, the same legal issues are questioned as to does IPRA or some other law prevent or permit access to these records. It is certainly the most efficient means for the court to resolve the issue of access to the records if this court in one action hears it all together, as opposed to competing actions filed with different, possibly even different judicial districts, possibly even in the federal court versus here. It certainly makes the most sense for Rule 24 to be applied in a way that allows the interveners to have these issues heard today. The other issue that I would set forth is that certainly the media interveners, their interests are necessarily affected and potentially harmed by an adverse ruling in this case. If in fact preliminary or permanent injunctive relief is granted, then the intervener's ability to receive the records that they've requested pursuant to IPRA are obviously harmed, and that should be heard here. We asserted some separate grounds in our motions, which were filed last week, I should say, in our responses, combined with the motions that talk about generally New Mexico permits members of the news media to intervene when their interests are affected by a ruling. That often happens when a court enters a gag order or a sealing of the courtroom or something like that that affects the media's right to intervene. That's certainly applicable here because the interveners are media entities, but it's actually not even necessary here because these interveners have made IPRA requests, and so they have a much more direct right to intervene. So unless the court has any questions, thank you.
All right, thank you. All right, Mr. Summer, do you have a response?
Your Honor, the right to intervene is not clear. I don't think that the cases cited by them, the New Mexico Associated Press versus Kaufman, gives them an absolute right of intervention. That case dealt with a prison riot case, a murder case, which had great public significance. The same thing is true with respect to the Archdiocese. They were dealing with matters dealing with sexual predators, and that had great significant public interest. Before they're allowed to intervene, I think that Your Honor needs to determine whether IPRA precludes the exclusion of these particular video cams and whatnot to the public at all, because under the exceptions of other law, under the IPRA Act, I believe that these records would not be subject to disclosure to anyone, because I think it would violate the rights of the Hackman estates to privacy and publicity. And also the family would be violated, their constitutional rights of privacy would be violated as well. And until those threshold issues are determined, I don't believe that the court should grant these motions to intervene. I don't believe that the press has any sort of vested interest in this case other than exploiting these deaths, these tragic deaths, for personal profit or gain. And so I would ask the court to not grant these motions at this time, or allow us sufficient time to brief it and argue these cases and leave the status quo in place and not disclose any records until we can fully brief these points, and Your Honor can make a proper decision. So on that basis, I would ask that you deny the two motions.
All right, Mr. Boyd, do you want to weigh in on this?
Your Honor, the county doesn't oppose these motions to intervene. We're not conceding the asserted rights that the media is claiming, but they do assert those rights to access these records. So we don't oppose the view that under Rule 24, or alternatively permissively, they should be able to participate as parties in this case.
Okay. And let me ask counsel for OMI. Mr. Souter, what's your position on these two motions?
Your Honor, thank you. The university has no position on it, one way or the other.
All right, Mr. McKenzie, now that your clients are a party to this case, do you have a position on this?
Your Honor, we haven't had a chance to evaluate the motion as we've just been granted leave to intervene. However, I do think that it does make sense to allow time for the issue to be fully briefed.
All right, Mr. Williams, you may have a reply.
Thank you, Your Honor. I would only briefly state that Mr. Summers' suggestion that the IPRA and privacy constitutional issues be decided first before the court determines whether my clients have the opportunity to intervene would seem to be the opposite of what the law and common sense would require. We want to have the opportunity to participate in the court's decision-making regarding the applicability of those issues, and for that reason, we believe the motion should be granted. Thank you.
I'm prepared to issue my ruling on these two motions. I'm going to grant both motions. They're appropriate and well taken under Rule 24. So the Associated Press and the CBS entities are now parties to this case. All right, one other issue I wanted to address, and that's the amount of time we have today. So at this point, we have about 3 hours. So, Mr. Summer, how much time did you anticipate in this proceeding?
An hour and a half, hour and 45 minutes.
From your case in chief?
From my case in chief.
Okay. And let me ask the board, how much time did you anticipate?
Your Honor, I don't anticipate that we'll be cross-examining any witnesses that they may be called, and so I don't expect us to be taking too much time in terms of the fact-finding portion of the court's hearing. However, we would expect 15 to 20 minutes to present our legal arguments regarding the request for preliminary injunctive relief.
All right, let me ask OMI. Mr. Souter, how much time do you anticipate?
Your Honor, the university has no witnesses to offer, and we will not be cross-examining any of the witnesses. However, maybe 5 minutes for oral argument if necessary.
All right, and Mr. McKenzie?
Your Honor, our position is the same. We don't have any independent witnesses either. We'll be buttressing what Mr. Summer has to offer.
And Mr. Williams?
Thank you, Your Honor. We don't have any witnesses to present. In terms of the time spent on cross-examination, it's a little difficult to predict because we don't know exactly what they're proposing to testify to or what the court will allow, but I don't think it'll be extensive. And I think in terms of arguing the motions themselves, 20 to 30 minutes at the most, depending on how the arguments go with the other parties whose positions we may adopt.
Okay. Give me just a moment if you bear with me for just a minute. And I'll establish the parameters on time that each party will have. All right, so, Mr. Summer, your client's gonna have an hour and a half to present their case. The county will have their 15 minutes that they've asked for. OMI will have their 5 minutes that they've asked for. Mr. McKenzie, you haven't articulated a specific amount of time, but I'm gonna give you 15 minutes. And then the media interveners, I'm gonna give 30 minutes. So that'll put us at about 2.5 hours, maybe a little bit more than that. And that'll give me time to make my ruling today. All right, so that's where we're at. Are there any other preliminary matters we need to address before we get into opening statements?
I have none, Your Honor.
Okay. The board?
No, Your Honor.
All right, and OMI, any other preliminary matters?
No, Your Honor.
And Mr. McKenzie, any preliminary matters?
No, sir.
And Mr. Williams?
No, Your Honor, thank you.
All right, Mr. Summer, let me hear your opening statement.
May it please the court. Your Honor, this case is about a celebrity couple who lived in very private lives in Santa Fe, New Mexico. They took great pains to stay out of the public light. They lived in a private gated community. They lived very quietly in Santa Fe, and unfortunately they died a very tragic death. They would not want to have their privacy invaded by having the tragic deaths exploited by the press. This case raises issues of right to privacy and potential security issues for the estate. Mr. and Mrs. Hackman had an expectation and the right of publicity during their lifetimes and after their deaths. They had a right to control their names, their likeness, and their image during their life, and the estate has the right to control their names, likeness, and images after their deaths. The Hackmans controlled access to their home during their lifetime. The Hackmans never conducted interviews in their home and never provided access to the press to their home. By releasing the video cams and investigative material to the public, the Sheriff's Office will be undermining that control exercised by the Hackmans during their life and the estate's right following their deaths. The disclosure of the videos is simply another way of circumventing the control the estate should retain, as the Hackmans did during their lifetime. The request for the video cam is nothing more than a backdoor exposure to the Hackmans' lifestyle that could not be attained by the press during their lifetime. The petitioner has pending 2 probates, and under the probate code, she has 3 months to conduct an inventory of the estates. By releasing the video cams of the Hackmans' home, the estate will make public an inventory of the home before the personal representative has time to conduct such an inventory. And further, since the probate code does not require the publication of an inventory, the release of the video cams will undermine the private probate process under New Mexico law and in fact violate the provisions of the probate code by the publication of the estate's probate inventory by publishing the video cams. Petitioner is thus seeking 2 determinations: a declaration that the estates of Gene and Betsy Arakawa-Hackman have a right of publicity to protect the name, likeness, and image of Gene and Betsy Hackman. A declaration that Gene Hackman and Betsy Hackman families have a constitutional right to privacy. The essence of this matter is that petitioner seeks a determination as to whether the estate's right to publicity and the family's right to privacy shall be infringed upon by releasing the sensitive items pursuant to the Mexico IPRA statute. IPRA is a sunshine law intended to disclose misconduct. No misconduct has been expressed in this matter. None. IPRA is about transparency in government action, but it is not an open-ended and does not allow the public and press open access to all government documents and material. There are exceptions. One of the exceptions is under the last exception under the code is under other law. And we would supply the court with other law being that there's a right to privacy and a constitutional right to control the publicity of the states. The public does not have an open-ended right to exploit the material for personal gain. And in violation of the privacy rights of the Hackman estates in particular, there simply is no legitimate government purpose for releasing this material at this time. A preliminary injunction is the only proper remedy in this matter. If the requested videos, photos, and cam records are released, the estate has no assurance of how the material will be used. A bell cannot be unrung. Once the images are released, the press will use and abuse these images without assurance. The press will exercise any bounds of decency. There simply is no guardrails to control the dissemination of material once it is released. Your Honor, petitioner seeks a preliminary injunction to protect the status quo. Continuing the order does not in any way harm any party to this action. OMI and BCC face no harm. BCC, if CBS and APA are allowed to obtain the material, there's no guardrail to protect the privacy rights of the estates and the right to publicity, which is controlled by the defendant's estates. Until this court has an opportunity to have a full trial and briefing on the rights of the estate and the rights of the family, there's simply no harm in continuing the order with a preliminary injunction. All we need show is a prima facie case that we have a right to injunctive relief. As Your Honor is well aware, to obtain a preliminary injunction, the petitioner must show that their plaintiff will suffer irreparable injury unless the injunction is granted. The threatened injury outweighs any damage the injunction might cause the defendant. The issuance of the injunction will not be adverse to the public's interest, and there is a substantial likelihood the plaintiff will prevail on the merits. Let's examine each of these points. In BCC's response, it asserts that redactions of the bodies will protect against any harms, and therefore we have failed to show irreparable injury. This is simply not true. As will be demonstrated by evidence solicited from Dan Crone, this display of the cams in total could cause great harm and security interests to the estate. The estates will suffer irreparable injury if the videos are allowed to be shown, because once they're shown, they're out in the public for public use and public consumption in any manner they deem appropriate. The estate will be injured as the images and the videos will depict the interior of the home, will display the interior contents of the home, ingress and access points for the property, locations of certain items, and will be subject to the estate to unnecessary expense to secure the property. It will also depict Gene Hackman and Betty Hackman's final days, with or without bodies. This will create unnecessary media frenzy. Further, and as dark as this may be, Your Honor, the images and videos have monetary value to the press. If the material is not properly secured to some unscrupulous person seeking to sell the images, if improperly obtained for the press, there could be significant sums of money passing hands based upon the photos that would be released. Future documentaries and movies about Gene and Betsy Hackman's life are understandably forthcoming. For this reason, these images, if released now, will place the estate in a difficult position of dealing with media fallout, the right to control their publicity, the security issues, and the estate loses the ability to control how these images are released in the future. All of these are very real concerns of the estate. Secondly, the families run the risk of irreparable injury. If the material is released, the families have to relive the deaths of the Hackmans. This will be repeated ad infinitum, as we will see, if they are released. The family will have to change the way they conduct themselves to avoid seeing the images that depict Gene and Betsy's last days. Sandy Warren and Louis Brandeis wrote at the turn of the century in The Right of Privacy, under 4 Harvard Law Review 193, that cameras and mechanical devices promise to make what is whispered in the closet available to the public. Thus, the concept of the right to be alone is conceived. Little did these authors know how this statement would become later in life, as the turn of the 20th century did not know of the internet and social media. Releasing the material will offend the community's sense of fair play and decency. Consider the case of Rochin, which is the U.S. case, United States Supreme Court case 342, U.S. 172, and the Favorish case. In Favorish, the court stated quote, "The public exploitation of death images degrades the respect accorded to families in their time of grief." 2, with respect to the second prong of our obligation to be met, threatened injury outweighs any damage the injunction might cause the defendant. Until the underlying legal issues are determined, neither the OMI nor BCC nor the media that's now been admitted will suffer any financial damage or harm by waiting until this matter is fully argued and litigated by the parties. There will be no damage financially to anybody by waiting and determining these legal issues. BCC asserts the injunction is overly broad due to the language disclosing through IPRA or other means, expresses concerns about disclosure of documents of federal investigators. If there's a concern about the federal investigation or any federal investigation of these documents, I think they could be separately addressed or they could be brought before the court in a separate motion. Other means is that we are seeking to try to have these documents secured in a proper way. The BCC has proposed that the court hold the documents and decide whether to determine them. I understood Your Honor's ruling today to be that you're not accepting the intervention or the interpleading of those documents. There's no damage to the media by waiting until these matters are decided. A significant amount of videos have already been released to the press. In fact, CBS Response admits that the news has already received videos depicting the outside of the home, videos showing conversations with witnesses. No damages have been alleged by any respondent in this matter. Issuance of an injunction will not adversely affect the public's interest. And no adversity for the public interest has been raised by the OMI or BCC. So adversity to the media. CBS asserts that IPRA provides them with a right to the records because of public policy that militates in favor of disclosure, and there is a very strong interest in the videos and images. This is a misstatement of public policy of IPRA. IPRA's stated purpose is to protect the public from bad actors in government, is government accountability statute, and is intended to protect the public and create transparency. If transparency is the court's concern, this issue has been addressed. The OMI and the Sheriff's Office conducted a press conference and provided the public and the press with newsworthy information regarding the Hackman's deaths. There's been plenty of media about that press conference. Further, and most importantly, there's a very substantial likelihood that the petitioner will prevail on the merits. The state will prevail on the merits because the state has a right to publicity, which is a property right which is transferable in life and continues beyond death. Gene's and Betsy's names, likenesses, and images are valuable and need to be protected. And it's clearly proven out by virtue of the press wanting to get its hands on the documents to exploit them for their own personal profit and gain. This estate has a duty to protect Gene and Betsy's property, including photographs and videos of their dead bodies. Judge Browning recently opined in Warner Brothers Entertainment versus Lloyd that the estate possesses a right of publicity for the decedents. The Smith case that's been cited here in this matter is old law. It does not reflect what has happened since celebrities have been hounded by the paparazzi and exploitation has occurred of many deceased people's bodies in the public. And if one looks at the current case law, not the Smith case in 1988, but the current case law, you will find that there is a right of publicity action that is designated for individuals who have placed themselves in the public eye. It secures them for the exclusive right to exploit the commercial value that attaches to their identities by virtue of their celebrity. The right to publicity protects the value as property, and its infringement is a commercial rather than a personal tort. Damages stem not from the embarrassment, but from the unauthorized use of plaintiff's property. By exploiting these images, they will be exploiting for their own private and profit gain the images of the decedents. The family will prevail on the merits because the family has a right to privacy as expressed by the Marsh line of cases. The Marsh line of cases, Your Honor, follow the Smith case, and New Mexico simply has not had an opportunity to review this issue of privacy at this time. But if it did, you would find that there's a plethora of cases, and New Mexico is in the minority of those cases, and it has not been brought before the courts of New Mexico about the right of privacy. But the Marsh line of cases surely overrules the Smith decision and stands for the proposition that a right of privacy exists as a constitutional matter, federal law, as a federal law. So the provision of IPRA allowing for other law, this would be a federal constitutional right which we seek to protect. So if one looks at the Smith case and how it's been cited, you will see that other courts, the Reedy versus Pierce County and the Katz versus National Archives, overruled Smith. They overruled it because of the personal right and the infringement on the privacy rights of the individuals and the violation of their constitutional right. The court finds that in the Reed case, that allowing access to autopsy photographs would constitute a clearly unwarranted invasion of the Kennedy's family privacy. Same is true here. If the autopsy report is disclosed with all the photographs attached, and if the video cams of the Sheriff's Department are disclosed, it will certainly provide an unwarranted invasion on the Hackman family and Arakawa family. Current New Mexico law expresses a minority view. Since the Smith case, that case has been developed and overruled in many other courts. We would submit to the court that the development of a constitutional right under federal law and the right of publicity under federal law should be applied as pursuant to the exception under the IPRA Act and prohibit the disclosure of this material. Your Honor, we intend to call 2 witnesses to support the propositions that I just stated. Dan Crone we intend to call to show that there is a risk of security and damage that could forbear or come upon the estate in the event that these images are shown in the public in terms of the estate damage and risk and security it may face. Secondly, we intend to call the Hackman's publicist, who's a representative, the companies represent the Hackman family for over 40 years, to show that there's a right of publicity and how they control their press during their entire lifetime. Thank you.
All right, Mr. Boyd, do you wish to make an opening statement?
Your Honor, I'll reserve my argument for after the witnesses giving their testimony.
All right. And Mr. Sauter, do you wish to make an opening statement?
No, Your Honor.
Mr. McKenzie?
Your Honor, we will also reserve until after witness testimony is concluded.
And the media defendants, or interveners?
Yes, Your Honor. Thank you, Your Honor. In the interest of time, I think I will reserve much of my argument until later in the proceeding, but I would like the opportunity to just briefly address some of the statements made in Mr. Summers' opening statement. This is, in fact, a motion for injunctive relief. It is, of course, the burden on the party seeking injunctive relief to prove each of the elements set forth in the 4-part test for injunctive relief. And it's our position that I'd like to talk a little bit further about what the court is going to permit in terms of testimony today and what relevance that testimony has to the legal issues. But regardless of the testimony that's being presented here today, it's our position that the petitioners will not be able to produce evidence sufficient for this court to enjoin, and we should be clear on what they're asking you to do here, that they are seeking to enjoin 2 state agencies, the Illinois Division of the University of New Mexico and the County of Santa Fe via the Santa Fe County Sheriff's Department, from doing what they are statutorily required to do via IPRA and what they do every day in cases not involving a high-profile matter like this, which is to produce records upon request of public activities and to do so as a routine part of their everyday job. And it is a very unusual request for any person or entity or estate to come to the court and say, we're asking you on behalf of our clients to enter an order that would prohibit state entities from doing their statutorily required roles. The particular records that are in question here are records that, as I understand it, of police activity that took place at the home in the form of photographs and video recordings, whether it be a lapel cam or body cam. And the other category of records is autopsy reports or materials collected by OMI or created by OMI in conjunction with their normal autopsy duties. And these are records that are, first of all, routinely produced by these entities in response to IPRA requests, because that's what IPRA requires. And second of all, in terms of the policy interests that are at play here as to whether these are sorts of documents representing police activity, representing OMI activity, representing public actions, are the kinds of records that should be disclosed. Our legislature is, of course, the entity that primarily, well, that is the entity that makes that decisions, has already weighed the public access concerns in determining that those are not exempt from IPRA, and therefore has already made the determination, presumably weighing all of the privacy interests being asserted here, and determined that those are matters of public record. The issue that's being raised here is petitioners are arguing to the court that, in fact, IPRA does not apply. And that's because there is a privacy right arising from the federal constitution that trumps IPRA. We're not disputing that the federal constitution falls within the as otherwise provided by law exemption to IPRA. That if there is a constitutional right that trumps IPRA, in fact, IPRA does not apply. But the evidence in the law in this case is going to demonstrate that, in fact, no such right exists in New Mexico in a way that trumps IPRA. And if it did, these entities or persons that are before the court do not have the right to, they do not possess the rights, privacy rights necessary to overcome them. And again, I said I'd be brief and I already went longer than I thought, and I'm not going to go into every detail. But it is clear, first of all, that these records are in fact not exempt under IPRA. And as to whether or not these entities have the privacy rights necessary to trump that is what the court will need to determine. And we've set forth in our opposition filed last week that, in fact, to the extent the estate is the petitioner, and up until this morning that was the only party seeking relief, that the estate, in fact, does not possess the right of privacy that's being asserted here. That particular right of privacy does not pass when a person becomes deceased. Under the law, the right to privacy passes with the decedent. It does not carry on. Now, the petitioners are now raising some maybe alternative arguments or different arguments that it has to do with an interest in the name or likeness or something to do with the property that the probate code would cover. I do not think that that is applicable. I do not think that they can demonstrate that that rises to a constitutional level that would overcome IPRA in this case. As to the claims being raised now by the new interveners, which are family members as I understand it, they too do not possess those particular privacy rights that they can provide on behalf of or in lieu of the deceased parties. And I think that Mr. Summer course, seized on the key case here, which is Smith versus City of Artesia, and the related case called Lucius versus Curtin, which is from the 10th Circuit, interpreting New Mexico law, which say that the right of privacy does not survive. And so their argument is that those cases from another era or somehow don't apply. But what's clear is certainly the Smith case is still New Mexico law. And we do not believe that the petitioners will be able to demonstrate that that case law should be ignored and that the court should find this right of privacy in a way that frankly defies the New Mexico law as it stands at this point. I'm not going through each of the preliminary injunction steps, the 4 steps, but I think that this goes most prominently towards the 3rd step, which is whether or not the petitioner has a strong likelihood of success on the merits. Because we do not think that. We do not think even the law or the facts eventually will demonstrate that they can win on the merits. For that reason, injunctive relief should be denied. Thank you.
All right, Mr. Summer, if you would call your first witness.
Mr. Conklin's gonna call Dan Crum and Director Jim.
Your Honor, may we be heard on this before the witness testifies?
What is your objection?
I don't want to take too much of the court's time, but we do have a document that was filed by the petitioners, I think it was last week, although we didn't make it to the court file till today, so I saw it today. It gives a little bit of information as to what Mr. Crone is prepared to testify to, and as I understand it, it's in the mode or manner of expert testimony as to, as he described it, the role of, well, I'll leave it to them to describe it exactly. I don't really understand what issue it goes to, and in light of the standing issues that we've raised and the legal issues, I'm not clear what factual testimony this witness can provide that is going to, I don't want to waste too much of the court and the party's time if this is not going to shed any light on any of the issues that the court needs to resolve today. I'd just like to lodge that objection and maybe ask the court for to ask the petitioners for additional information as to what information is going to be provided by these witnesses.
I haven't issued any type of scheduling order that requires the petitioner to provide additional information to the other parties in this case. So I'm denying any objection that you have at this time. You can assert any objection, appropriate objection, if necessary, during the person's testimony. All right, Mr. Crone, why don't you come up? I'm going to swear you in.
Thank you, Your Honor.
Watch your step going up the incline there. All right, do you swear or affirm that the testimony you will give in this case will be the truth, the whole truth, and nothing but the truth on the ground of law?
I do.
All right, you may be seated.
Thank you.
Good morning, Mr. Crone.
Good morning.
Can you please state full name for the record?
Yeah, it's Dan Crone. Last name is spelled C-R-O-N.
Thank you. And what is your occupation, sir?
I'm a lawyer.
And where are you licensed to practice law?
That's the state of New Mexico, United States District Court for the District of New Mexico, the United States District Court for the District of Columbia, and I am an inactive member of the bar in Ohio.
Thank you. And how long have you been licensed to practice law in New Mexico?
Well, let's see, come May 13th, it'll be 43 years.
That's a long time. Do you have a particular area of expertise that you practice in?
I do.
And what is that area of expertise?
Criminal law.
How many criminal cases would you say you handled over your career?
Thousands.
In connection with your practice, do you have occasion to view police body camera and video evidence?
I do.
On average, how many hours per year do you think you would say that you review police body camera and video evidence, lapel videos?
Between 1 and 200 hours a year.
Does your review of evidence also include videos taken by the police of the residences, interior residences of people's homes?
Yes.
And what do those videos generally depict, sir?
Well, the body cams are located, they're also called lapel cams. They're located on the front of the police officer, so any direction that the police officer happens to face, then everything that's within the purview of where they're facing is depicted.
Very well. So would you say that this includes details of the interior of a house?
Absolutely.
When a major scene is being investigated inside a house, would you expect the complete interior of the house to be depicted on the videos or other images?
Yes.
Why is that, sir?
Well, it's because during the course of an investigation, they are looking for all possible relevant evidence to the inquiry. And so therefore, they really go to every inch of the house to see if there is some evidence that might inform the investigation.
Do you have any experience in high-profile cases, sir?
Yes.
Is it fair to say that in cases that have the potential to be high-profile, that the police may have more officers at the scene than other cases?
That's inevitably true.
Do each of those officers on the scene have their body camera video activated, sir?
Yes.
And why is that?
State law.
When there are a lot of officers on the scene, are there multiple videos that depict various inside and outside locations of the house?
Yes.
In connection with your work in criminal defense, are you familiar with the motivations people have to commit various crimes?
I am.
Your Honor, at this time, petitioner would move to have Mr. Crone qualified as an expert in criminal law and what is depicted in body cams at the scenes being investigated.
All right, Mr. Boyd, any objection?
Your Honor, as to the qualification for expertise in criminal law, I would have the objection to that. As to what body camera footage depicts, I believe that he's not an expert in that. He's relaying his own personal recollection of what of the body camera footage he himself has viewed. I don't know how he can speak to body camera footage in general beyond what he himself has viewed. So I would object to that portion of the qualification.
All right, Mr. Souter, any objection?
No objection, Your Honor.
Mr. McKenzie?
None.
And Mr. Williams?
May I be heard briefly to question the witness?
All right, I'll allow you to voir dire the witness.
Would you prefer that I do it here or would I?
Nope, you need to approach the podium.
Good morning, Mr. Crone.
Good morning.
I'm just going to ask you a few questions.
Sure.
As I understood your testimony, you were not at the scene of any of this particular police investigation, is that correct?
For the Hackman estate?
Yes.
That's correct.
Have you seen any of the photographs or the camera footage regarding this particular investigation?
No, well, nothing beyond what's already been disseminated.
So in terms of what the petitioners are seeking to keep from the public, in this case, you've not seen anything, is that correct?
That's correct.
And have you spoken with anyone who has reviewed those materials?
No,
Have you spoken with any of the police officers who did the particular investigation or made these recordings?
not on this case, no.
Those are all the questions I have. Thank you.
All right, so do you have any objection to qualifying this witness as an expert in criminal law and lapel camera footage?
So my objection in the area of criminal law is I'm not certain what the relevance is of that to any issues, and so I guess my objection is not to his qualifications, but as to the relevance of any such testimony to this case, as to his expertise regarding police camera usage or photos, he's not demonstrated that he has any particular knowledge in regard to this case, and therefore his testimony would not be of any particular use to the court. Thank you.
All right, so I'm going to qualify this witness as an expert in criminal law. With regard to the second prong of that request and denying the request, the relevancy issue, I'll give it the weight that it deserves, the testimony, the weight that it deserves in making my rendering that final decision. All right, you may continue.
Thank you, Your Honor. Mr. Crone, I want to ask you some questions concerning the estate of Gene Hackman. Based upon your knowledge and expertise, do you have any concerns about the release of to the public of the body cam videos and photographic images taken during the investigation?
Yes, I do.
And is there a specific, excuse me, is there a specific case that you had that raises concern regarding these images and videos?
Yeah, there is a case that I think has applicability, yes.
And what kind of case was that, sir?
It was a murder case,
Was it a high-profile case?
yes,
Was the case heavily covered in the media?
it was.
What forms of media covered the case, sir?
Print media, TV stations, and social media.
And what kind of facts were included in the media coverage?
Facts that were included in the media coverage were the fact that what turned out to be my client was incarcerated as a result of the charges, that there was no bond at the time. The address of the client's house was made public, and because of the nature of the coverage, it was inescapable to conclude that because the incident occurred at that house and that one of the two residents of the house was dead and the other resident was in jail, the inescapable conclusion was that the house was vacant.
So what ended up happening in this case to cause you concern about the release of public and body cam videos taken during the investigation of the deaths of Gene and Betsy Arakawa-Hackman?
There were two burglaries.
And what happened in the first burglary, sir?
Well, in the first burglary, there was just some credit cards and driver's license that were stolen.
And did the burglars do anything else during that first burglary?
Well, they did. It turns out that they cased the rest of the house so that they could come back and steal items and have the proper means to carry the stolen items out.
So after the first burglary, was the house secured?
Yeah, neighbors came over and secured the access point.
And did the same burglars return to the house a second time?
They did.
And what did they steal on the second burglary, sir?
Well, after they broke in, they stole several $1,000s worth of goods, and they also stole a van that was handicap equipped for a wheelchair.
Apart from the stolen items, were there any other damages to the home?
Yes, the place was completely ransacked. Every drawer was pulled out. Things were strewn all over the place. And there was also physical damage to the house as a result of the ransacking.
Based on your experience in that case, do you have any concerns about the release of the Hackman videos and photographs in this?
I do.
Is there a particular criminal element that you're concerned about, sir?
Well, yes. It's no secret that Santa Fe has a significant drug problem. There's a lot of drug trafficking that goes on. And the concern that I have is that the images from the body cams and the photographs would eliminate the need for that first step that happened in the case that I'm talking about, and basically give potential thieves a blueprint as to not only the contents of the house, but because of the images of the body cams of everything else, that it would also show the most vulnerable access points for burglars to get in.
Mr. Crum, are you aware of any other instances where high-profile individuals' houses were burglarized?
I am.
And what do you know about those cases?
Well, they were highly publicized last year during the course of the NFL season, when it was known to burglars that the homes of Patrick Mahomes, Travis Kelce, and Joe Burrow, and some other NFL stars. Of course, it's known when they're playing away games, and their houses were broken into, and the last account that I saw was that $2 million worth of their property was stolen while they were away.
Do those cases affect your concerns about the potential for criminal activity taking place at such act now?
Well, they do, because the release of, like I said before, the release of these videos and images in question would provide a blueprint for what to take, how to get in, and what kind of means that they would need in order to haul those goods out of there. With one of your previous questions, what happens with the drug traffickers is that they steal items and then sell them for pennies on the dollar to gain money for the drug activity. And in this particular case that I had, this van that was specially equipped was sold for $500 and some drugs. And, it was apprehended by an alert sheriff's deputy who saw the vehicle at the, getting gas at the Smith's at College Plaza. Then once that, the driver who had purchased it was apprehended, that then opened up the investigation that ultimately caught the people who were involved.
And Mr. Crum, last question, would you say that the release of these photos and videos would cause irreparable harm to the estate, leading to damages?
Objection, Foundation. Overruled.
Would you ask the question again?
Yes. Would you say that the release of the photographic and video evidence collected by the Sheriff's Office and the OMI, I guess, well, we'll just stick with the Sheriff's Office, would cause irreparable harm and lead to damages to the estate?
I do, in the case that I had, because of the nature of how these goods are disposed of by the criminal element. The only thing of the thousands of dollars worth of, things that were stolen out of the house, the only thing that was recovered was the van itself. The like I say, there were thousands of dollars of other items that were stolen that, you know, just evaporated, and you couldn't get them back.
I would agree with you, Mr. Brown. That's all the questions I have.
All right, Mr. Boyd, any questions?
Just two questions.
All right, if you can approach the podium for me.
Good afternoon, Mr. Cronin. Did I hear you, I want to confirm your testimony during voir dire. You testified that in your experience, police officers generate lapel camera footage and videos during police activities, and that's as a result of a duty under state law, is that correct?
Yes.
And with respect to the client, you related the experience that your client had with a house that was left unoccupied. You said that the damages that were suffered were in the form of theft and burglary to the inside of the house. Is that correct? Burglary of goods inside the house?
Well, and damage to the house, you know, from both the break-ins and the ransacking.
And the theft of a van?
Yes.
No further questions, Your Honor.
All right, Mr. Souter, any questions?
No, Your Honor.
And Mr. McKenzie?
Yes, sir.
Afternoon, Mr. Crum.
Hello.
Hi, Greg McKenzie. As you might have heard, Mr. Levin and I represent the children of Gene Hackman. I have a few questions for you. So I heard you in your direct examination testify that in your experience you would expect there to be multiple lapel cam recordings. Is that correct?
Yes.
Okay. And just so I'm clear, that's because every officer responding to this scene would have been wearing a lapel camera, correct?
Yes.
Okay. And then in connection with that, I take it your testimony is that you would expect to see many images of dead bodies in this case, correct?
Your Honor, if I may object on the grounds that the court has already excluded his testimony as an expert on this particular topic.
I'm going to overrule the objection.
Thank you, Your Honor. Based on your experience as an expert in criminal law, is it your testimony that you would expect to see multiple images of dead bodies in the videos and lapel cams?
Absolutely.
And as an expert in criminal law, what is the purpose of, what would be law enforcement purpose in documenting the dead bodies at this residence?
Well, it would be as part of the investigation to determine things like, you know, was there foul play? What was the position of the bodies? You know, what surrounding the bodies might inform how things occurred, things like that.
And so in your professional opinion as an expert in criminal law, is it your opinion that the activity of law enforcement at the residence on this day was a law enforcement activity?
I would describe it as a law enforcement investigation.
And so therefore, the videos that result are law enforcement records, correct?
Yes.
What is your experience with respect to audio recordings that go along with those? So, and without getting terribly gruesome, but do the lapel cameras also record audio?
Yes.
And so in the event of a sheriff's deputy who is examining the body of my client's deceased father, would you expect there to be a audio description about what that deputy is witnessing as he's witnessing it?
You hear that all the time. You know, observations that are being made, and the other thing that you get is conversation back and forth between various deputies talking about how things are pieced together and what might be of significance.
I see. So, to the extent that a media outlet were to obtain a lapel camera recording, they would see images of my client's deceased father as well as the verbal conversation of sheriff's deputies describing what they're seeing. Is that right?
That's correct.
No further questions, Your Honor.
Mr. Williams?
Thank you, Your Honor. Mr. Crone, in regard to that last line of questioning, I just want to make clear, you have not, you said that you've not seen the video or the photographs in this particular case, is that right?
Yeah, that's right.
And I assume that also means that you have not heard any of the auto recordings, is that correct?
Yes, that's correct.
And you have no other source of information as to the content of those recordings because you haven't spoken to any of the police or anyone who's reviewed them, is that correct?
Yes.
In regard to the testimony that you gave earlier regarding a prior case, your client that was arrested and there was a subsequent burglary, let me ask you just a couple of questions. First of all, in this case, it was alleged in the petition that the date of the discovery of the two deaths at this particular home was around February the 26th. Does that sound right to you?
I really don't know.
Do you have any reason to disbelieve that particular date?
I have no reason to believe or disbelieve. I just don't know.
Okay. Today is, as we sit here, March the 31st, so a little more than a month has passed. Are you aware if there have been any attempted break-ins or vandalism or other crime at that particular location in that time?
I don't know one way or the other.
Okay. You would agree with me that starting from the first date of the public disclosure of the finding of these particular deaths, that there has been significant media attention to the deaths, correct?
Sure.
And that includes right here in Santa Fe, the Santa Fe newspaper and the local TV stations have covered and made the public aware of those particular deaths. Is that correct?
Well, yes, as will the testimony from today and the reason for the concerns.
And notwithstanding that publicity, you're not aware that anyone has attempted to break in or approach or enter the property since that day. Is that correct?
Objection, Your Honor. Black's Foundation.
Well, that's what I'm asking. Do you know?
Overruled.
I'm sorry, can you say that again?
Notwithstanding the significant publicity regarding the deaths that has taken place since around February the 26th, would you agree with me that there have been, to your knowledge, there have not been any attempted break-ins or vandalism or other attempts by criminals to access the property?
Well, I have no basis to know one way or the other. For example, I don't know if perhaps there have been potential burglars going there trying to determine from the outside where an access point might be. And so, it's, when I say I don't know one way or the other, it's entirely possible that there has been someone with designs on doing something who may have already gone to the property and just nobody knows about it.
All right. But no one has told you of any break-ins or approaching or casing the residence as you're describing here. Is that correct?
Well, no, and I have not asked, and no one has raised that subject with me, so I have no knowledge one way or the other.
Do you have any information whether the estate or the family has provided some security for the residents?
I don't know.
Do you have any reason to believe that the estate or the family lacks the financial resources to provide security for the residents?
I don't know what the resources are.
Would you agree that providing security would help protect the residents and likely prevent kind of access that you mentioned in your previous client's case?
Now say that again.
Sure. You talked about in the previous case that there was a couple of incidents, break-ins or otherwise, at the home. Is that right?
Yes.
Do you know if there was any private or other security provided to that particular home?
Well, I know that the neighbors were keeping a very close eye on the property because they knew that the property was not occupied and that they were concerned that there might be break-ins.
Beyond the neighbors keeping an eye on it, do you have any information about whether or not there was security provided for the home?
As I understand it, the sheriffs were doing drive-bys.
But in this case, just to be clear, you're not aware whether or not there is any private security that's being provided to the home?
I have no idea one way or the other.
I don't have any further questions. Thank you.
Any follow-up?
Nothing further, Your Honor. Thank you.
All right, just to let you know, Mr. Williams, you've used 17 minutes of your 30 minutes, and the estate has used 32 minutes of their 90 minutes. All right. Mr. Summer, you'd call your next witness?
Yes, we call Susan Medora, who is on the,
So let me back up a little bit, I apologize. So is there any reason to retain this witness?
no, Your Honor, you can be released.
All right. And let me ask, County, any reason to retain the witness?
No, Your Honor.
And Mr. Sauter, any reason to retain the witness?
No, Your Honor.
Mr. McKenzie?
No, sir, he could be excused.
That's fine, Your Honor.
All right. So Mr. Crone, you've been released as a witness. You're free to go about your business. Thank you.
Thank you.
All right. Mr. Summer, you would call your next witness.
Yes, we call Susan Medora, who's on the video camera.
All right, so Ms. Medora, is it Ms. Medora or Ms. Medora?
Medora.
All right, Ms. Medora, if I can have you raise your right hand for me. Do you swear or affirm the testimony you will give in this case will be the truth, the whole truth, and nothing but the truth under penalty of law?
I do.
All right, you can go ahead and put your hand down, and you may proceed.
Thank you, Your Honor. I think it's still morning. Good morning, Ms. Medora. Can you please state your name for the record?
Susan Medora.
And Ms. Medora, what do you do for a living?
I am a publicist.
And if you don't mind, can you please tell the court the name of the company you work for?
It's called Gutman Associates.
And what does Gutman Associates do?
We do entertainment publicity.
And what is your title at Gutman Associates?
Currently co-CEO.
And how long have you been with Gutman Associates for?
27 years.
Ms. Medora, did you know Gene and Betsy Hackman?
I did.
And how long had Gutman Associates represented Gene and Betsy Hackman for? Excuse me.
Yeah, we've represented Gene since the beginning of his career, so about 60 years.
Can you briefly tell me about the Hackmans? What were they like?
Yeah, they were lovely, kind, wonderful, funny, private. Gene was a little shy and reserved until you got to know him. Betsy was wickedly funny. She had a really wonderful sense of humor.
You had said that you've worked for Gutman Associates for 27 years.
Yes.
Did you work with Gene and Betsy for the entire 27 years?
Yes. Yes, Teresa.
Can you tell me, was privacy important to them?
Yes, very.
Do you know how long the Hackmans resided in Santa Fe for?
They moved there before I started working with them, so I would assume sometime in the 90s.
Do you know why the Hackmans chose to live in Santa Fe?
Yeah, Gene made a movie in Santa Fe and really fell in love with it. He liked that it was remote and private, and he could have his anonymity there. He also, at that point in his life, had started painting, and he enjoyed that he could really experience an artist's life in Santa Fe.
Do you know if the Hackmans chose to live in Santa Fe having anything to do with their desire for privacy?
Yes, I believe so. They didn't like They didn't like everything that LA had to offer them in terms of awareness. They liked their privacy and they liked their private life in Santa Fe.
Do you have any brief stories that you could tell the court regarding any affirmative steps that Mr. and Ms. Hackman took to protect their privacy?
I do. I remember a couple of years ago, Betsy called. She wanted to let me know that they were buying a piece of land because Gene liked to ride his bike there, and he wanted the privacy of being able to ride his bike without anyone, following him or observing him. But she wanted me to let me know. She wanted to let me know specifically because the property is adjacent to the city dump, and she wanted me to be aware if anyone called asking why Gene Hackman lived at the dump, what it was about. More recently, in I think January or early February of this year, I was talking to a producer from CBS News Sunday morning, and they were asking for Gene to do an interview with them, and he had declined, and he has declined for years. And so they called to let me know that they were going to go to Santa Fe and do a piece on Gene without his participation. They were going to go to find people who knew them and get a sense of who they were and do the story that way. And when I told Gene and Betsy about it, they were horrified, really upset. And so I called the producer back and I asked them, can you please not? They would be really upset by this. And they agreed, and they decided not to do the piece. They didn't want to upset Gene and Betsy.
Thank you. Ms. Bedore, in your opinion, did Mr. Hackman take his name, likeness, and image seriously?
Very.
Did Mr. Hackman ever have a rider put into any contracts that you're aware of that might limit the publicity that he was to perform on a movie?
I'm not sure if it was ever contractual. I don't see those things, but for every movie he did, he only ever agreed to generally 2 hours of press on any movie.
Do you know if Mr. Hackman's movie contracts ever permitted him to retain the rights to his name, likeness, and image?
I believe they did, yes. Like, for instance, if any entity wanted to use a clip of Hoosiers in which Gene appears, he has to approve that first.
And did Gene ever deny the approval of the use of those clips that you're aware of?
Often. Yeah, very often. He generally approved things that were for artistic purposes, museums, art showings, things like that, but commercial usages, news programming, things like that, he would generally decline those.
Through your representation of Mr. Hackman, did you ever have to take affirmative steps to protect Mr. Hackman's name, likeness, and image?
Yeah, in the sense of correcting stories or turning things down, turning interview requests down, asking people to, leave them alone, nicely, no, sorry, that's not going to work, that sort of thing, for sure.
In your opinion, if the autopsy photos or videos or images of his last days or Betsy's last days were released to the media, how would this impact his name, likeness, and image?
It's interesting. It's an interesting question. I think that for anything like that to be out in the public, any entity can use it however they want, in perpetuity. And that's not something, he would have never agreed in his life for that to happen, so why would we think he would agree to it in his death?
Can you tell me what steps your firm would generally take to counter negative publicity for a client?
Yeah, it would sort of be an all-hands-on-deck situation, really time-consuming, reaching out to every single media outlet, responding to every reporter, which is time-consuming.
Do you believe that the autopsy photos or videos and images of Mr. and Ms. Hackman's last days have any economic value if leaked to the press?
Objection,
Yes.
variation.
All right, overruled.
Can you repeat the question?
I think you answered it, but I will repeat it. Do you believe that the autopsy photos or videos and images of Mr. and Ms. Hackman's last days have any economic value if leaked to the press?
Yes, for sure. People could create movies, podcasts, anything, and they could monetize it.
And in your opinion, do you believe that the release of certain images and videos would negatively impact Mr. and Ms. Hackman's name, image, and likeness?
Yes, I do.
Or is it good this time?
All right. Let me ask the county,
We had no questions for this witness.
and OMI, any questions?
No questions for this witness.
Mr. McKinsey, any questions?
No, sir.
And intervening media,
No questions, Your Honor.
any reason to retain this witness?
No, Your Honor.
All right. Unless there's an objection to me retaining this witness, I'm going to go ahead and release her. Any objection from anyone?
Your Honor.
All right, Ms. Medor, you've been released as a witness. You're free to go about your business. If you want to stay on Google Meet, you're free to do so. But if you wish to disconnect, you're free to do so as well.
Great, thank you.
Thank you for your time today.
All right, let me ask, Mr. Summer, any other witnesses?
I have no other witnesses, Your Honor, except I would like to point out to the court that Yoshi Feaster, who is Betsy Arakawa-Hackman's mother, has entered an appearance in this motion to intervene, and she also submitted an affidavit with a motion. She was unable to testify under doctor's orders due to the stress it would cause her with respect to having to do the testimony. So she will not be testifying, but it is in the court record.
Okay,
And that concludes our presentation as to evidence, Your Honor.
all right, thank you.
Thank you.
Okay, so let me go ahead and ask the county, you had reserved on opening. Do you wish to make an opening statement now?
Your Honor, I guess you could call it a closing statement. I think I'd like to make my legal arguments, vis-a-vis the evidence in the context of a closing statement. We don't have the evidence to present beyond what's set forth in our response to the petition.
Okay. No other evidence from you. All right, Mr. Sauter, you indicated that you weren't calling any witnesses. Is that still the case?
That's correct, Your Honor.
And do you reserve on an opening? I guess you reserve, so, but you're not presenting any evidence.
That's correct, Your Honor.
Okay. Mr. McKinsey, any evidence?
No, sir. Like the county, we like the ability to address the court with our legal points, but that's all.
Okay. And media interveners, any evidence that you wish to present?
No, Your Honor.
Okay. So at this point, I think we should move into closing statements.
Your Honor, I'm sorry. Respectful of the court's time, would it be possible for us to take about a 5 or 10 minute recess, considering that I think that part moved a little faster than we thought? Just
Yeah, let's go ahead and do that. We've been going for an hour and a half. Now would be a good time to take a break. So if you all would be back in the courtroom at, let's see, 1:15, and we'll reconvene. So we'll be on recess now.
All rise.
It was really nice.
Right letter.
Is your battery life still doing okay on the microphone?
Yeah.
Do you want to check it?
Well, let's just go ahead and change them. Good idea. There's like, there's still battery left though.
All rise.
You may be seated. We are back on the record in the matter of DO 101 CB 2025-612. I know that all parties are present in the courtroom. And we're going to move into closing argument. Mr. Summer, let me hear your argument.
Your Honor, for purposes of today's hearing, the petitioner needs to show that it has a prima facie case in order to get a preliminary injunction until these legal issues can be fully briefed and decided. We need to show that there will be some irreparable harm or injury unless the injunction is granted. We need to show that there's a threatened injury outweighs any damage the injunction might cause to the defendants. The issuance of the injunction will not be adverse to the public's interest, and there is a substantial likelihood that we will prevail on merits. With respect to the first prong of this test, Your Honor, it's clear that if these images are out in the public, we can't get them back. They will be disseminated on social media and the internet, and it will cause damage that we cannot undo. So letting any of these images of the deceased body or the residence or the location of assets or inventory of the assets into the public cannot be undone once the images are released to the press or to the public in general. This threatened injury, Your Honor, and damage will not cause any harm or damage to any of the defendants by waiting until we determine the legal issues on this particular matter. There's been no showing by either BCC, OMI, or any of the media plaintiffs or defendants that they will be damaged by holding off on granting of the preliminary injunction, while Your Honor takes time to allow a full litigation of the issues in this matter and determine the full legal weight of the issues we've raised. Further, the injunction will not be adverse to the public's interest because this is not a crime matter. It's not some issue of nefarious activity by the sheriff's office, and there's no issue of public interest other than purient interest to see what these bodies look like, what the house looked like. Things that could not be known except by showing the video cam of the scenes of the decedent or the complete autopsy report that has been prepared by the OMI. We think there's a substantial likelihood to prevail on merits in this case for the simple reason that we think there's a right of publicity. We think that the right of publicity is established. If I could, Your Honor, approach the bench.
All right, if you can show opposing counsel that.
I've given opposing counsel a copy of the case, Your Honor.
Okay.
Yeah, I've seen this session.
It's a fairly recent decision, Your Honor. By Judge Browning on the Federal District Court of New Mexico. But the critical thing is that Judge Browning found in this particular case that there's a right of publicity in a decedent and that it is inheritable or can be passed on. And the interesting thing is, in this particular case, we think this sets the law in New Mexico today and should be recognized by this court, and not concerning the Smith case, which dealt with a civil rights action solely dealing with whether the decedent who was deceased had a right of civil rights action under the Smith case. Very different from the one in this case. The decedent in this case, both of them, valued, as we saw from the testimony from Ms. Bedora, that they valued their right of privacy. They controlled the disposition of their names, use, and likeness in every possible way. They took absolute control over that circumstance, and that right of publicity, therefore, was set forth in them. And if we look at page 5 of this particular case, Your Honor, the right of publicity is an action designed for individuals who will place themselves in the public eye. It secures for them the exclusive right to exploit the commercial value that attaches to their identities by virtue of their celebrity. The right to publicity protects that value as property, and its infringement in a commercial rather than a personal tort. Damages stem not from embarrassment, but from the unauthorized use of the plaintiff's property. The name, use, and likeness of these decedents is a property right that it resides in the estate. And as such, the estate has a right to assert that in this particular case, if the video cam is disseminated, that there will be damage which will be irreparable to the estate as a result, because it will not be able to control the dissemination of that information.
All right, so let me go ahead and identify on the record the citation to this case. It's Warner Brothers Entertainment Incorporated versus Lloyd. And it's a March 29th, 2022 decision. And it's 2022 WL 1749514.
Thank you, Your Honor. The evidence also showed, in addition to what Ms. Medora testified to, that video cam testimony or video cam, the use of video cam by the sheriff or any other law enforcement is thorough. There's been no dispute that this was a thorough investigation. There's been no allegation that it was faulty. So we must expect that the video cam in this particular case, with as many people as were on the site, was pretty thorough and will disclose both the body and the language and the intent of each of the officers involved to disclose and investigate this scene. The scenes will also show the contents of the property. As I pointed out to Your Honor in my opening, the probate code allows a personal representative to take 3 months to do a complete inventory. If this is released now, that would breach that 3-month period because she was just recently appointed. Furthermore, the probate code does not require the publication of an inventory. This showing of the video will breach that particular privacy provision of the probate code. So we think there will be damage as a consequence to the estates if those video cams show the interior of it. Finally, Your Honor, under IPRA, this is 4-2-1.2, law enforcement records are public records, and there was no dispute when Mr. Crone was asked whether the video cams and the voice overtake on them were law enforcement records. And I think that we need to look at that they were in fact law enforcement records. The reason I raise that is under 4-2-1.2A3, visual depictions of a dead body unless a law enforcement officer acting in that capacity caused or is reasonably alleged to have suspected to have caused the death. They're to be excluded. So even if Your Honor fashions a preliminary injunction that's not what I'm asking for, which is complete withholding of these video cams and the audio until the matter is heard, at the very least, they ought to be redacted of all the pictures of the body. Furthermore, Your Honor, it's unfortunate, but OMI records are not law enforcement records. As a consequence, if the full autopsy report is shown, the IPRA request could encompass showing the pictures of the bodies having been autopsied. So that too would be damaging to the estate, to the rights of the plaintiffs in this case, and so we would ask that they be excluded. We think that the right to inspect public records exception that's set forth in 14-2-1M, as otherwise provided by law, allows for the complete withholding of the video cams and the autopsy report in this case. If Your Honor, however, does not find that we're entitled to a complete withholding of it, we would ask the following. At the very least, that Your Honor grant a preliminary injunction that does one of two things. Either allows the media or anybody seeking the videos or those images to be able to go in and inspect them without copying, photographing, or otherwise disseminating those records, and have a right to inspect them in person with an oversight and controlled circumstance so that those records are not disseminated. We think that's a risky proposition, however. You don't know whether somebody's wearing eyeglasses that take photos. You don't know whether somebody is wearing some device that would allow for a photographic of any of the records, and that's a dangerous proposition. So while we don't recommend that, that is an option so long as there's some safeguards taken. Otherwise, Your Honor, we have to ask that the court at this time, given the preliminary showing that we have made, to withhold all of the records at this particular time, or to fashion a remedy that allows for the production of the autopsy report redacting all of the photographs, which I believe the OMI would stipulate to, and all the personal information in the reports with respect to showing of the video cams and the whatnot, that if they're shown, that any video cams, if Your Honor is not granting my full motion, show and allow only pictures of the house that don't show any valuable art, don't show the position of entries and exits, don't show the bodies of the decedents, and redact all voice communication regarding the bodies. Thank you, Your Honor. Appreciate your time.
All right, so Mr. Sommer, when you say no personal information out of the OMI records, are you referring to like Social Security numbers?
Social Security numbers, health information.
All right, thank you.
Thank you.
All right, Mr. Boyd.
Your Honor, I want to note at the outset and address the comment made in the Hackman State's reply brief that the county is holding the public's right of access above the privacy interests of the Hackman family. That's not correct. If the county had the power to honor the grieving family's moral right to privacy, no doubt would do that. But the county is a legal entity. It's created by the law, and it has to comply with the obligations it has under the law. And the county's position is that the law does not give the county any discretion to deny a request to inspect the sheriff's office records that are issued in this litigation. As Mr. Williams alluded to earlier on in today's presentation, the Inspection of Public Records Act, including the law enforcement records provision that has been addressed by my friend representing the Hackman estate, does the relative balancing of privacy versus the public's right to know. And the specific exception that everyone has been discussing here is the exception that allows the redaction of visual depictions of a dead body. And you can see the balancing at work even in that provision, because there's an exception that says that a redaction can be made unless a law enforcement officer is alleged to have caused the death. And so, again, the legislature has decided that the public body can redact this information when there's no law enforcement involved in the death, but if there is an allegation that a law enforcement officer has caused the death, the redaction is not permitted. So the county lacks the discretion to entertain the privacy right being asserted here. I think the county's position is that IPRA is dispositive. With respect to the right of publicity being asserted in the reply brief, the county's position is that right, as am I reading the case law here, applies to commercial exploitation of name, image, likeness. So while the Hackman estate may have a claim against a media entity that is exploiting Gene Hackman's or Betsy Arakawa-Hackman's image and likeness, that's their claim to pursue. It doesn't address what IPRA requires by way of production in response to a request for public records. I would also note, Your Honor, that IPRA affirmatively precludes the county from inquiring into the reasons that someone is submitting a request for public records. That is section 14-2-H8-C, sub C. The county is precluded from asking someone, why are you seeking these records? And so I think that, again, under IPRA, the statute that the county is required to follow, the county doesn't have the discretion to say, well, hang on, are you seeking to improperly exploit the name, image, likeness of the Hackmans? That discretion is not there under the statute. I don't know whether the media interveners are continuing to make the argument they've made in their briefing intervention, which is that these are not law enforcement records and that therefore the county can't make any redactions. Our position is that these are clearly law enforcement records. They are body camera footage and photographs taken during a search of a house conducted pursuant to a lawfully issued search warrant. It's, I think, abundantly clear that these are law enforcement records, and the fact that search did not terminate in criminal charges does not bear on the status of the records themselves. And so the county is permitted to redact visual depictions of dead bodies from these records, and it will do so. It has done so. Your Honor, I want to step back and talk about what I think to be the troubling precedential issues that this case raises. As we point out in our brief, the county receives thousands of Inspection of Public Records Act requests every year. And as the expert witness, Mr. Crone, testified, state law requires sheriff's deputies to take lapel camera videos of their interactions during law enforcement activities. So these records are going to be created in the ordinary course of law enforcement, and they are, as Mr. Crone testified, going to be created for any home search. So the court's recognition of a potential right to privacy that would preclude disclosure of these records creates not only administrative difficulties for the county in terms of deciding where the right falls. You heard counsel, Mr. Sommer, say that the relief they're seeking isn't just inside of the house. They want to go in and have a really fine-tooth comb approach to what can and can't be shown. They don't want to show fine art. They don't want to show entryways to the house, all this kind of stuff. And so the problem the county has is how does it comply with that right going forward? And also for the court, there are a lot of records that were generated by this search, and the court is going to be in a position of having to go through and decide, which portion of which record might implicate the right to privacy and whether its release would violate that right to privacy. And so there are administrative difficulties with the injunction being requested that the court should be aware of as it reaches a decision. note, I want to discuss briefly the position for the argument made in reply that the Dundee Grant case allows the county to deny records requests. The petitioner has pointed to that case as authority for the proposition that this court can enter an injunction barring a release of records, and that order then serves as a basis to deny inspection of Public Records Act request. In that case, that was a discovery order under Rule 26, and the discovery order was issued in a case involving the same parties as the follow-on IPRA litigation. It was a contested order. The parties fully litigated the issue of whether these records should be released pursuant to Rule 26, and then the counsel for the losing party sought those records under IPRA. And the court reached the decision, the right decision, that he has otherwise provided by law exception allowed the public body to deny inspection of records that the court had prohibited from disclosure under Rule 26. Here we have a bootstrapping problem. The court needs to recognize some legal basis to deny inspection of these records in order for the county to have a permissible basis to withhold. And unless the court enters that kind of order, in this case in contested litigation, the county is exposed to liability in front of a different judge if someone decides to bring a separate lawsuit asserting their rights under IPRA. And that tags on to the Interpleader issue. I know the court has asked for briefing on that, but I want to note for the record, we have all of the responsive records on thumb drives that are ready to be deposited with the court. They're here in the courtroom with us now, and so we're prepared to deposit them. And understanding that the court wants to fully brief the propriety of Interpleader, we just don't want to have anyone argue that, well, if we really wanted to pursue Interpleader, we wouldn't have deposited the records with the court. We are in a position to do that today and can do that right now. I have nothing further, Your Honor.
I have a question for you.
Yeah.
What's your position on the audio recordings that describe deceased, the decedents?
Well, Your Honor, the IPRA exception at issue here, law enforcement records, that provision, section 1.2, I believe it is, states that a public body may redact visual depictions of a dead body. So our position is that we don't have discretion under IPRA to redact audio. And again, separate from that legal question, there's also the question of how far any redaction order goes. If the court is of a mind to redact conversations describing the dead bodies, is that going to include conversations that occurred outside the house or later or before? I haven't reviewed all these videos, so I can't speak to what is within these conversations. But again, part of the irreparable harm prong here, as well as the public interest, since we are a government defendant, is the cost that's going to be imposed from having to go into the area of complying with the judicial order and figuring out exactly what the scope of that order is vis-a-vis redactions. And the last point I'll make on that, Judge, is that if the court enters an order like this, preliminary injunction is one thing, but the court should be aware that the county is a legal entity that has existed for as long as the state of New Mexico has existed. It will continue to exist for as long as the state of New Mexico exists. And the other administrative difficulty of this is, how does the county ensure that these records don't get released in 10 years, 15 years, 20 years? It's just going to be a kind of ongoing problem that I think does go to the harm that will be caused by the requested injunction and balancing the harms that the court needs to assess in deciding the motion.
All right, thank you. All right, Mr. Sauter, let me hear from you.
Thank you, Your Honor. I'll be very brief. We recognize our obligations and accept those obligations relative to the Inspection of Public Records Act. We also recognize that the autopsy photos are public records. Having said that, the OMI has long believed that those autopsy photographs are incredibly invasive, are very much disturbing, and can be quite traumatic and embarrassing to the family and their kin. Having said that, we will follow whatever the court's directive is, and meet our obligations under IPRA. Turning to the autopsies reports themselves, Your Honor, those reports do not exist today. No autopsy reports have been issued in respect of either of the deceased. If the injunction is not extended into a preliminary injunction, then we would produce those autopsy reports when they are issued in a manner consistent with IPRA. Having said that, just so that the parties understand, we would redact out personally identifiable information pursuant to New Mexico statute section 14-2-1.1, but would also redact out information that identifies specific individuals as patients under the otherwise provided by law exception in IPRA, and pursuant to New Mexico statute 14-6-1, which provides and makes clear that past healthcare information is absolutely confidential, even in the hands of a governmental entity. With that, Your Honor, thank you for your time.
All right, thank you. Commissioner McKenzie?
Thank you, Your Honor. Our client's main concern, Judge, is that there is no dissemination of video recordings or photographs of their deceased father. In addition, their primary concern is that there's no dissemination of audio recordings of their deceased father. Now, Your Honor, I'm sure you've been thinking this through as you've been hearing the evidence, but what we're really talking about, Judge, is my client's father, who lay dead for some amount of time, and all of the grotesque pictures that go along with that, and the conversations of deputies discussing that. There is no limit to the trauma that could cause my clients for years to come with that information, as the media publicist has already testified to, would likely show up on the internet or in podcasts, etc. In this hearing today, Your Honor, there's been a lot of references, obviously, to IPRA. That's what we're here about. But I'm not sure that there's been a very careful recitation of exactly what IPRA provides. And so I'd like to just very briefly go through that. Mr. Williams, in his comments at the beginning, indicated that the legislature had already done the balancing test, and you heard Mr. Boyd say the same thing. And I would submit that that's actually largely correct. Section 14-2-1 states that every person has a right to inspect public records of this state except, and that statute then states exceptions to the rule. There are two exceptions to that which are relevant to the court's decision today. The first is exception D as in dated, portions of law enforcement records as provided in section 14-2-1.2. Now that section specifically says that law enforcement records are public records except section A3, visual depictions of a dead body unless a law enforcement officer acting in that capacity caused or is reasonably alleged or suspected to have caused the death. That's obviously, Your Honor, not at issue here. There is no question that visual images of Mr. Hackman and his wife are completely accepted from this IPRA requirement by black letter law. I frankly don't even understand how news media could come in and assert some kind of right to get those images because they are clearly accepted. Now, with respect to the audio recordings, the statute 14-2-1 also accepts records which might otherwise be protected as provided by law. That is subsection L. Mr. Williams, in his opening remarks to the court, made much of the Smith versus City of Artesia case. And I know that, Your Honor, you're taking notes. This is found at 108 New Mexico 339. This is a 1989 Court of Appeals opinion. There are things that are in that opinion that the court should pay careful attention to. In particular, at paragraph 9 and paragraph 10 of that opinion, it is clear, in fact, it is explicit in those paragraphs, that the reason for the outcome in that decision was because there was no United States Supreme Court case which granted a right of privacy for one person to protect the death images of a family member. At issue, Your Honor, in the Smith case was the release of a daughter's murder photographs, and the ultimate conclusion was that the release of those photographs did not violate a constitutional right. The court got to that decision because of a lack of federal authority on that. However, what Mr. Williams didn't point out to you is that after the 1989 decision of Smith versus City of Artesia, there have been a whole host of federal decisions, including a United States Supreme Court case, that expressly recognizes the right of privacy in this context. Not, as Mr. Williams said at the beginning, we are not saying that the estate has the right of privacy. My clients have a right of privacy for their father's death images to not be cast over the internet in perpetuity, as well as audio recordings about his decomposing body. Those cases have been cited in the briefing. They include the National Archive and Records case, which is found at 541 U.S. 157. This is a 2004 United States Supreme Court case that specifically says, while in the context of FOIA, which of course is not IPRA, but it's in the context of FOIA, it says family members have a personal stake in honoring and mourning their dead and objecting to unwarranted public exploitation that, by intruding upon their own grief, tends to degrade the rights and respect they seek to accord to the deceased person who was once their own. And that is exactly where we are here. So that case recognized the privacy right, and then that decision has been followed up in numerous other decisions which have been discussed before you today. One of them is the Marsh versus County of San Diego decision, which is a 9th Circuit 2012 decision. It's cited in the briefing. That question involved whether the dissemination of a child's death picture by a district attorney who photocopied the picture before he left the office of DA, and then it got leaked to the press, whether there was a 1983 action. And in that case, the court said that yes, disseminating this death picture violated the rights of privacy and therefore gave rise to a 1983 claim. In addition, there's the case of Lee versus City of Seattle. This is a Washington appeals opinion from 2018 that dealt with the release of suicide photos. The court found that the release of those photos would shock the conscience and offend the community's sense of fair play and decency. The release of death scene photographs fall within the other statute exemption under the Washington Public Records Act, which is exactly the argument that we are raising here today. And by the way, Your Honor, not to belabor the point, but there's been a 10th Circuit opinion dealing with this exact issue called Prison Legal News versus Executive Office for the United States, to be found at 628 F. 3rd, 1243, and it has the same ruling. Bottom line is, Your Honor, is that under IPRA, there is no question that the depictions of Mr. Hackman's dead body and his wife's dead body are not public records, they are not discoverable, and on top of it, there is no question that our clients have a privacy right to keep the recordings of the discussions of their father's dead body out of the public domain. And Your Honor, that is our position. We strongly object to the production of any photographs dealing with their dead bodies and the audios that go along with them. Thank you.
All right, Mr. Williams.
Thank you, Your Honor. May I ask, because I know you're keeping track how much time I have left?
You have 13 minutes.
All right. All right, then I'm going to be as brief as I can and try to cram a lot of information into that time period. So we are here, as I said at the beginning, for the court to determine whether, in fact, it can enjoin the University of New Mexico and the county from performing its statutorily required duties in this case. I'm going to start, first of all, with the two witnesses that testified. I didn't hear much from counsel for the estate or the intervener regarding the relevance of that testimony. I would briefly say I think that testimony was of little or no use to the court. I think Mr. Crone, although he's certainly a very well-regarded lawyer, admitted that he has no information about the particular recordings or photographs. In this case, he gave a story about a client that he had represented in the past, whose house had been broken into. There's no indication that will happen in this case. It has not happened in the month that's gone by to this point. The idea that the recordings will provide some sort of a roadmap is purely speculative, and I would ask you to disregard that testimony. The same goes to the publicist. I think the point of her testimony was primarily that that Mr. and Mrs. Hackman enjoyed their privacy and were careful in the use of their name, image, and likeness during their lifetimes. But as I'm going to talk about here in terms of the test for preliminary injunction, I don't think that either of those are particularly relevant for the court's consideration. So let me, with an eye on the clock, move through the four elements that they were required to prove. And I don't agree, first of all, with Mr. Summers' statement that all he has to make is a prima facie case at this point. I think he is required to prove each element of his case at this stage if the court is going to continue its temporary injunction. So let me talk about, first of all, the overriding interest, which is, well, I'll just go through them in order. The first question is, can they demonstrate, have they demonstrated irreparable harm based on the disclosure of these materials? And they have not. What they have provided is some speculation as to whether or not someone who had access to this information would use this. But the bigger picture is, do these particular entities, does the estate and the intervener have the ability to raise these claims as a matter of standing? It seems to be clear from the law that, in fact, the right of privacy does not succeed a death, and therefore the estate does not have the right to bring a claim for loss of privacy after the death has occurred. They've twisted that argument a little bit because they want to talk about what I think they're asserting as a property right that arises out of the name, image, and likeness of the decedents, with the idea that others are not permitted to make commercial use of someone's name, image, or likeness. Whether or not that succeeds a death, and I'm not certain that it does, I don't think that case provided to you from Judge Browning, which is a Connecticut case, has any relevance. The point being that there is a news gathering exception for that. News gathering and news usage is not considered a commercial use for these purposes. And so to the extent the estate is trying to raise a lost property interest, they haven't proven that they have done so or that they will suffer irreparable harm. I didn't understand the argument about the probate estate having, or the the personal representative having 30 days to conduct an inventory. There's nothing in this case that's before the court that would affect the ability of that personal representative to conduct that inventory or to take any other steps within the personal representative's duties. As to the right of privacy that's being asserted by the intervener, I disagree with counsel's assertion of the law. I think the Smith case that's cited in our briefs makes clear that the right of privacy does not succeed and that it does not otherwise belong to a successor or a family member. And there were some case law cited at the end that I have not yet been provided with, but I encourage the court to read the case, the Smith case. There is certainly not a Supreme Court or a 10th Circuit case that overcomes that or in any way overrules that right. So in terms of irreparable harm, I do not believe that they have demonstrated that. There is in fact a public interest that they have to override. The public interest is in public records, the performance of public duties by the county sheriffs and by OMI. There certainly is a public interest in the passing of the Hackmans. The Hackmans were, especially Mr. Hackman, was a very well-known individual. There's been worldwide coverage. There is certainly a public interest in knowing how their deaths were investigated and how that matter was handled. They've not demonstrated that their slight claim, their speculative claim of irreparable harm overcomes that public interest. And I want to focus on the third element, which is the success of the merits. And this brings us to IPRA, right? Because there seems to be no question that IPRA applies. And so the question is, in a normal case, what is public under IPRA? And I agree that we focus on the right statutes. The one statute that's been brought up by Mr. Boyd and by the other counsel is 14-2-1.2, which is, I think, only a 2-year-old statute, a new interpretation of law enforcement records. The reason that we, the media entities, said in our briefing that these were not law enforcement records is because that's what the petitioner said. The petitioner said in the petition, in a footnote, that neither the house nor the cause of death is being investigated as a crime. They specifically pled themselves out of the applicability of that exception. And if you look at the definition of law enforcement records, in that section, it says, evidence in any form received or compiled in connection with a criminal investigation or prosecution by a law enforcement or prosecuting agency. And so by their own pleading, they have said this doesn't apply. If it doesn't apply, they haven't pointed to any other exception in IPRA other than the constitutional argument that would exempt these records from IPRA. If the court is inclined to disagree with plaintiff's own pleading on this and find these to be law enforcement records, then we do agree that the cited sections are what should apply, which is the visual depiction of a dead body or the visual depiction of great bodily harm. To the extent IPRA applies, then that should be redacted and not provided. I would like to say, we said this in our briefing, and I want to reassert it for the court. The media entities that are intervening here have already said in the petition, in our opposition, that they do not intend to make public pictures of bodies at the scene. That to the extent any of this is published, that they will blur those images so that they are not made public. And I want to make sure that that's clear to the court. That seems to be what IPRA requires anyway, and we are not disputing that. As to the audio recordings, the court has no discretion in interpreting IPRA to exclude those audio recordings, and that's because the legislature has not done so. The legislature has gone through 2 years ago and decided in protection of personal privacy, when there are situations where law enforcement is investigating or looking at a death scene, that they are going to prohibit or exempt visual depictions of a dead body, visual depictions of great bodily harm. There's no exception for audio recordings. You may think that, or consider, or want to believe that there are policy considerations that would protect that, but the court's not permitted to do that. The court, under the Republican Party case, is not permitted to substitute its own policy balancing for that of the legislature. If you go to the next exception, which is 14.2-1.2A6, it exempts visual or audio depiction of a notification to a member of the public of a family member's death. That shows that the legislature considered the issue of what audio records to exempt, and it specifically limited it to the notification of family members of deaths. They did not extend it to anything related to the body. The court simply does not have the discretion to do that. I'd like to close by saying that the media entities are sympathetic, very much so, to what the Hackman family has gone through. There's been a lot of discussion today, or allegations about exploitation, things like that. And the media is not interested in any of that. They are interested in receiving the records that the law requires OMI and the county sheriffs to provide. And that's the extent. I would argue that under the evidence presented to the court today, the petitioner has not met, or the interveners have not met their burden to show that this injunction should continue. They have not demonstrated irreparable harm, overcoming the public interest, and they have not demonstrated that they are likely to succeed on their own. So I'd be happy to answer any questions.
All right, thank you.
Thank you.
All right, Mr. Sommer?
Thank you, Your Honor. I want to clarify something. The probate code allows a personal representative 90 days to conduct an inventory of the estate. With respect to not having met our burden today, I think if you look at Logan versus Public Employees Retirement Association, which is found at 216 U.S. District Court, Lexus 33, you will find that all we need to make is a preliminary showing that we would have success on the merits, not that we've proved our entire case. I think we've made a preliminary showing in this matter, sufficient to warrant the injunction that we're asking for. And so I would ask the court to enter the injunction until these matters can be fully briefed. Your Honor can make a certain decision with respect to the two legal issues that have been raised, right of publicity and right of privacy. I would also point out that under section 14-2-1.2C, the last sentence says, any recording or copying of a video or audio from such viewing or listening is subject to the restrictions of this section. It would seem to me that anybody describing the body, although that's not a visual depiction, would certainly fall within that exception of not providing that information to the public if the court rules that the records are to be disclosed. So I don't know how that reads completely, but I point out to Your Honor under subsection C, that last sentence seems to indicate that.
Can you give me that citation again, please?
Yes, it is section 14-2-1.2 and it's subparagraph C. And this deals with the law enforcement records and the visual depictions of bodies. It also talks about video recordings. And if you're going to talk about the bodies in the video recording and describe them, it would seem to me that it would go along with the visual depiction. So thank you for your time. Any other questions?
No, thank you.
Thank you.
All right, so at this point, I'm going to go ahead and take a recess. I'm going to take a 30-minute recess or thereabout. So if you all would be back in the courtroom at 2:35, and then I'll render my decision. So we'll be in recess until 2:35.
All rise.
to get into San.
Takes a while,
Don't do that.
Phoenix on there.
Phoenix on there.
How long is the layover?
Pounds, but not that. I've seen an hour and a half. Here to Phoenix is nothing. I mean, you're up and down for 40 minutes.
Okay.
There are lots of flights out of Phoenix, that's a good thing.
Yes. So we are back on the record in the matter of DO 11 CV 2025-612. I note that all parties are present and the court is prepared to issue its ruling. To obtain a preliminary injunction, a plaintiff must show, 1, the plaintiff will suffer irreparable injury unless the injunction is granted. 2, the threatened injury outweighs any damage the injunction might cause the defendant. 3, issuance of the injunction will not be adverse to the public's interest. And 4, there's a substantial likelihood plaintiff will prevail on the merits. Injunctions are a harsh and drastic remedy which should issue only in extreme cases of pressing necessity and only where there is a showing of irreparable injury, which there is no adequate and complete remedy at law. It is not enough that the party seeking injunctive relief merely claim irreparable harm. He or she must come forth with evidence of the irreparability of the harm or inadequacy of any remedy. With regard to the different elements the court must consider, it stands to reason that petitioner and the intervening children would suffer irreparable injury, at least in relation to the dissemination of death scene and autopsy photographs of Mr. Hackman and Ms. Arakawa-Hackman, unless a preliminary injunction is granted. To the extent the court grants a preliminary injunction prohibiting respondents from disclosing certain records, respondents may rely on the preliminary injunction as an exemption to producing particular records. And that's reflected in Dunn versus Brandt, and that is reflected in that particular case. The public's interest will be adversely affected if a preliminary injunction prohibits disclosure of records otherwise available to the public pursuant to IPRA. I have reviewed the following cases: Lee versus City of Seattle, Marsh versus County of San Diego, National Archives and Records Administration versus Babash, Smith versus City of Artesia. I've also reviewed the relevant IPRA statutes. There is strong support for the court to issue a preliminary injunction regarding any photographic or video depiction of the deceased bodies of Mr. Gene Hackman and Miss Betsy Arakawa-Hackman. However, petitioner does not cite any authority to unequivocally support the issuance of an injunction relating to autopsy reports, general depictions of the interior residence of the decedents, or depictions of deceased animals. Marsh versus County of San Diego stands for the proposition that the 14th Amendment of the United States Constitution recognizes a family's right to privacy over death scene images showing a deceased person based on or upon substantive due process and, in certain circumstances, procedural due process protections. While the Supreme Court in Favish primarily analyzed the government's application of FOIA Exemption 7C, the Supreme Court's reasoning emphasized the well-established cultural tradition acknowledging a family's control over the body and death images of the deceased, which has long been recognized in common law. In Lee versus City of Seattle, the Washington Court of Appeals principally relied on the reasoning set forth in Marsh to conclude that the trial court did not err when determining that release of any death scene photographs would violate the substantive due process rights of the family. Specifically, the Washington Court of Appeals held, pursuant to the analysis set forth in Marsh, the trial court correctly concluded that the release of the death scene photographs would shock the conscience and offend the community's sense of fair play and decency, violating the family's substantive due process rights under the 14th Amendment. Permanently enjoining the city from disclosing those photographs, according to this court, is a reasonable way to prevent such a violation. Given the above authority, any depictions of the deceased bodies of Mr. Hackman or Miss Arakawa-Hackman are very likely protected from disclosure by IPRA's Law Enforcement Records Exception, Section 14-2-1.2A3, and IPRA's Catch-all Exception, Section 14-2-1L. Specifically, the court recognizes a 14th Amendment substantive due process right to privacy afforded to the families of Mr. Hackman and Miss Arakawa-Hackman. Further, the court relies upon the U.S. Supreme Court authority and ruled that the common law protects a family's right to privacy and control over death scene images. Excuse me. The above discussed authority lends little support to enjoining respondents from disclosing any autopsy reports, assuming no photographs are included within the report. Visual depictions of a deceased animal or visual depictions inside the residence of Mr. Hackman and Miss Arakawa-Hackman, assuming neither individuals within the photograph or video frame. It's also, my ruling also pertains to any audio recording. As to autopsy reports, the Office of Medical Investigators Regulations undercut petitioner's position that the autopsy report should be withheld from the public. Critically, those regulations identify the final report of death, the autopsy report, and the toxicology report as public records. The court grants in part and denies in part petitioner's amended petition for preliminary injunction. Petitioner has established that petitioner and the families of Mr. Gene Hackman and Ms. Betsy Arakawa-Hackman would suffer irreparable injury unless the court grants a preliminary injunction. Petitioner has established that the threatened injury does not outweigh any damage the injunction might cause the respondents. Petitioner has shown in part that the issuance of an injunction is not adverse to the public's interest. Petitioner has shown in part a substantial likelihood that petitioner will prevail on the merits. The court preliminarily enjoins respondents from publicly producing through the New Mexico Inspection of Public Records Act or other means any photographic or visual depiction of the deceased bodies of Mr. Gene Hackman or Ms. Betsy Arakawa-Hackman in any format whatsoever, including any investigatory photographs, lapel camera footage, or autopsy photographs. The court otherwise denies the request for preliminary injunction. All right, Mr. Summer, if you would prepare the order, I'll need that from you by the end of the week.
Your Honor, I have one clarification on the audio portion of your order.
Yes. So I'm denying the request for a preliminary injunction as it pertains to the audio. Any other clarification on any?
I have no other clarification.
Your Honor, I think I understood your oral ruling to be one, that the county is enjoined from producing any photos, videos, other visual depictions of the deceased bodies of Betsy Arakawa-Hackman and Gene Hackman. And I just want to make sure that it's the depictions of the bodies and not outright refusal to disclose the video itself. The reason I'm asking this is because my understanding is that certain portions of the video have been blurred out to remove the depiction of a body, but otherwise display the inside of the house. And so I want to make sure the county is aware of its obligations under the court's order, whether it should outright omit from disclosure any videos that contain in any part the visual depiction of a body, or just the visual depiction of the body from the video.
And I'm enjoining the county from disclosing any visual depiction of the bodies. All right, Mr. McKenzie.
Thank you, sir. Not to belabor a point, but just so I'm clear, Your Honor, earlier the court's ruling was that the ruling applied to audio, and I heard what you just said to Mr. Summer, but I want to make sure I'm clear. Are audio recordings enjoined, or are they not enjoined, sir?
They are not enjoined.
Thank you.
All right, Mr. Sauer.
No questions, Your Honor.
And Mr. Williams.
Just for further clarification over here, as I understood in response to Mr. Lloyd's question, to the extent there is video, that they have artificially blurred depictions of the bodies, that is not enjoined, is that correct?
That is not enjoined. So any depiction of the body needs to be, there shall be no depiction of either body in any video production or lapel production or in any image. That's my rule.
And so if they produced that video in which the body had been blurred, that would be consistent with the court's order?
That is consistent with my order.
Thank you.
All right, if there's nothing else, we'll be in recess, and I'll anticipate that order from you, Mr. Summer, by the end of the week.
Thank you.
All right, thank you. Thank you, Judge Hill. I'm another hearing with 10 days, so same point.